I'm from Zimbabwe. I recently finished my law degree and I work for an organization called Veritas Zimbabwe. We do monitoring and I'm here for freedom online and expression.
My name is Christoph. I'm from Belgium. I work for a UK charity that works in the area of online child protection.
Hello, my name is Keishu. I'm from China and I'm studying international human rights in the University of Nottingham.
Good morning, I'm Nina. I'm working for the Constitutional Court as an assistant magistrate from Romania.
Hello, my name is Claudia Sora. I'm working also in Romanian Constitutional Court.
Hi, my name is Hanna. I'm from Poland. I just graduated from my Master's of Humanitarian Action in Dublin. And I'm currently looking for anything that will be involved in human rights, from internship, volunteering, anyone who wants. Thank you.
Hello, good morning. I'm Gabriela, I'm Brazilian, and I'm working with social environmental issues for building scenarios in a company in Brazil. Nice to meet you all.
My name is Rama. I come today. I'm doing my master actually in Belfast. I'm doing international human rights and transitional justice.
Hi, my name is Rebecca. I'm from the United States. I'm also studying in Belfast, doing my LLM in Human Rights Law and Transitional Justice.
Hi, my name is Russell. I'm an attorney with expertise in pensions and social protection, and I'm beginning a degree in conflict resolution in the United States this fall.
Hi, my name is Amber. I'm a doctoral student in peace and conflict studies, and I'm from New York.
Hi, I'm Jennifer from Norway. I work with the Office of High Commission for Human Rights with the Special Rapporteur on the situation of human rights defenders.
Hi, my name is Charlotte. I'm from Germany and I'm working for the University of Bochum and I'm doing my PhD in refugee law.
Hi, I'm Francesca Asylum and I'm a PhD student from the University of Milan.
Good morning, my name is Neil. I'm Irish, but I'm working with the International Humanitarian Law Resource Centre in Jerusalem.
Hi everyone, my name is Greg Campbell and I'm interested to introduce me to you all. And I'm working as a junior judge at the Egyptian State Council. I'm from Egypt. My task is to give records to the new case administered law, and I'm interested to get more experience in human rights. And actually, my opinion is to get more experience in the whole field of law, and then specialize in one that is one area.
Good morning, I'm Raphael. I'm French and I'm a human rights counselor for the EU delegation in Beijing.
Hi, good morning. My name is Laurence. I'm from Luxembourg and I currently work with the United Nations Development Program in New York and I was in Nicaragua.
Hello, my name is Lisa. I have a degree in European Public Comparative Law and I work at the University of Luxembourg for the European Migration Network.
Hello, my name is Morgane, I'm French and I work on gender equality in the workplace.
Hi, my name is Carolina. I'm a teaching and research assistant at the University of Vienna, focusing on international law and international rights.
Good morning to everyone. My name is Alice. I'm from Latvia, Riga. Last year I finished my master's in international relations, and currently I'm working in the public sector.
Good morning, everyone. My name is Diana. I'm from Latvia as well.
I prepared government's observations of alleged violations of the European Convention on Human Rights against Slovakia. I'm working also on the public sector.
Hi everyone, I'm Noriki. I'm from Greece. I'm my master degree in public and constitutional law, and I'm working for a non-governmental organization called the Greek Council for Refugees.
Good morning, I'm Norta. I'm from Rome, and I recently finished my master's degree in international relations.
My name is Kim. I'm a law student from Berlin.
Hi, I'm Florence. I'm currently a student of a master degree of conflict resolution, and I'm French.
Hi, I'm Laura from Armenia. I'm working for the OSCE office in Yerevan under the police assistance program. And we are currently providing assistance to the Armenian police, trying to reform them to the new European standards, let us say, and I'm here. And I'd like, on behalf of all of us, to thank for organizing this wonderful event. And we hope to get enough, sufficient, proper, and lots of skills and competencies to continue our work for this year. Thank you.
My name is Rasha. I'm Palestinian living in Lebanon. I work with UNHCR in Beirut since 2007. I've been very much involved in refugee work, so I'm interested to be here. Thank you very much for this opportunity.
I'm Ben from Scotland. I've just finished studying my public international masters in Utrecht in the Netherlands, and I'm currently serving as a business and human rights NGO in The Hague.
Hi, my name is Joaquin. I'm Uruguayan Mexican, but I live in Canada. I finished my master's 2 days ago, actually, before coming here. And I'm doing my PhD in political science and law. And I'm also a member of the Human Rights Research Center at the University of Ottawa.
Hello everybody, I'm Federico, I'm from Argentina. I am a criminal lawyer and I did a master in the US on international human rights law. And I'm currently the legal director of the immigration bureau of my country.
Hey, I'm Hugo. I'm half German and Peruvian. Grew up in Germany and now living in France, actually, in Strasbourg, and working there for the European Court of Human Rights as a lawyer.
Hi everyone, my name is Gladys. I'm a lawyer at Veritas and I'm currently working on a project monitoring key human rights and constitutional cases. I'm from Zimbabwe. Hello, my name is Jenny. I like long walks on the beach. Sorry, I didn't warn. Everything's so serious here. But anyway, I'm South African. I'm doing my PhD in Brussels on business and human rights.
Hi, my name is Konstantin Kalamcha. I'm from Moldova, currently working with the United Nations Joint Program on HIV/AIDS in Ukraine. I am the Rights, Gender and Community Mobilization Advisor with UNAIDS Ukraine, taking care of monitoring human rights of the vulnerable groups. That means people living with HIV, LGBT community, and others. Thank you.
Hello everyone, my name is Agata, I'm Polish and now I live in Strasbourg and work at the European Court of Human Rights, like Hugo, as a lawyer.
Good morning everyone. I'm yet another lawyer from the European Court of Human Rights. I'm Ukrainian, my name is Oleg, and I'm interested in the intersection between business and human rights.
Hello, my name is Andrei from Russia. I'm a student of Master Program International Protection of Human Rights.
Hello, my name is Zafia Gurmays from Kazan, Russian Federation. In the International Protection of Human Rights, I wish you all students success. Good morning, my name is Natasha. I'm also from Russia. We are group students. So I also a master student in the program of international protection of human rights. Nice to meet you.
Hello everyone, my name is Luis Antonio. I study and work in Moscow University, and I am from Ecuador.
Hello, I'm Elena. I'm from Russia, and I'm a student of human rights in Moscow as well.
Hello everyone, my name is Olga. I'm from Russia too, and I'm a first year student of master's program, which contains two components: the protection of human rights and the law of European Union. Thank you.
Hello, my name is Alina. I'm Russian, and I'm a lawyer at the European Court of Human Rights.
At the Russian side.
Hello, I'm Christine. I'm from Belgium. It's a pleasure to come back here because I've done the EMA some years ago, and nowadays I'm working in Guatemala at the OHCHR.
Actually, I'm always very impressed because you are coming from all over the world. China, Russia, Peru, etc., etc. It's always fantastic. Meeting of people. Okay, just to tell you that actually we have a special agreement with the Office of the High Commissioner in Moscow. That's the reason we have 10 or 8 students from Russia. But they promised me, because I saw them last in Moscow, they promised me not to stay together. And stay together. Yes, at the end of the summer school, I want you to mix with the others. So
We mix them up. We mix them up this year.
Okay.
They're not together.
Okay. Then I wanted to tell you that it's nice to study. I understand. I did study a lot in my life. But don't forget you are also one of the most beautiful cities of the world. It's very simple and beautiful. So don't forget to go to Venice, to visit the museum, to visit, even if there is a lot of tourists. That's when you live in Venice, you meet tourists. Too many tourists, okay? But go and see Venice. And don't forget also that on the other side of the monastery you have the beaches. Beaches. When you swim, okay, so take your basic suit with you. It's a sea. So, Martin, I think if you want to start, let me just thank you once more for you to come here.
Thank you very much for us. It's good to be back in Venice and good to be back at the monastery. Indeed, I was involved in the master's program in the earlier years on behalf of Abo Academy University in Finland. I think it's about 10 years since I last taught in the master's program. I did come back later than that for I think it was a closing of the academic year of the master's program, the degree awarding ceremony, and there was a panel, and that was only 6 graders. Okay, we have the morning Bible today. And I have the honor and pleasure to give what's called the opening lecture. And I was asked to speak not about this vineyard, but about the relation between human rights and counterterrorism, largely based on my 6 years of experience as a national session rapporteur on human rights and counterterrorism. I've been dealt with the topic of human rights and the fight against terrorism as an academic, and as a UN Special Rapporteur. This mandate was created in 2005. It was a consequence of the 9/11 terrorist attacks of 2001, but it took several years before the governments could agree at the United Nations level what kind of a human rights mechanism would be needed to address the specific human rights violations or other problems resulting from the fight against terrorism. The outcome was a new special rapporteur, and I started on that mandate in 2006. It should, however, be mentioned that earlier than that I served 8 years on the Human Rights Committee, which is the body under the Covenant of Civil and Political Rights. And there on the committee, I was the committee's rapporteur, main drafter of the General Comment on States of Emergency, General Comment number 29, which became kind of a point of reference concerning human rights and counterterrorism. Technically, it's not a general comment on terrorism or counterterrorism, but about states of emergency and the power of governments to derogate from the provisions of the NCC in the name of fighting terrorism. Even better? No? Yes? That was small talk, and now I will start my lecture. So I formulated the topic, human rights versus public security. Are we ever going to resolve the tension? We often are confronted with the metaphor of a balance between security and human rights. And it has become part of the public discourse. We see it in the political discourse, we see it in journalism, and sometimes we see it even in judicial decisions, where people tend to say, yes, human rights are important, but there must be a proper balance, or somebody says, a new balance, because of the new or more serious threat of terrorism and what it poses to security, individual and collective security in our societies. So largely, human rights have been compromised during your lifetime. 2001 seems to be long ago for most people like me, but for you it's about half your lifetime. You have lived in the atmosphere of compromising human rights because of the terrorism threat, which then was manifested in the September 11 terrorist attacks in New York and against the Pentagon in 2001. The heading suggests it's not a contradiction, it's a tension. And when it's a question of tension, there can be various ways of resolving. And I'm trying to, in this lecture, to address possible solutions which are partly academic and partly practical. How to see that relationship between public security and human rights. I'm going to dismiss the simplistic metaphor of a balance, which is here's human rights, here's the objective of countering terrorism. They are two equal objectives, and there's freedom to choose which way to go. That's not the correct answer. I think we can be analytically much more rigorous, and we can seek tools and solutions how to resolve that tension without compromising human rights, without denying the importance of human rights and their normatively binding force. I am a lawyer, and when I speak about human rights, I primarily speak about human rights law. So to me, the balance is to be sought within the law. But of course, philosophers can address the same issue as a moral question, that there are certain moral rights of the individual that must not be compromised because society would compromise its moral foundation if it were to deviate from human rights in order to fight against terrorism. So let's get started. We have had the so-called long decade, which is 13 years long, since September 2001, of counter-terrorism measures. We can call it a long decade, or we can call it a big wave. The wave metaphor suggests that there's been a peak and then we are already going down on the other slope of the wave, and things are becoming better controlled, better balanced, if you want to use that metaphor. Terrorism continues to be a real threat to democratic societies. There are bad guys out there. They are organized, they have weapons, and it's part of the deeply troubling dilemmas of our postmodern societies that today every individual has the capacity to become a global actor. Previously, you had to be rich, educated, from a good family, from a good country, and with a lot of luck in order to become somebody who matters internationally. But nowadays, with what we call the postmodern society or one-dimensional globalization, everybody matters. We have instantaneous communication through electronic means across the globe. We can form and join communities anywhere in the world. We reach people, we meet people, we are able to organize across borders. We don't need physically always even to cross borders. If I don't have a passport, or if our government prevents us from moving, still we are able to do things and collaborate with others. And then there are people who have funds, people who have skills, and when others join forces with them, you can be just a loser to be recruited to terrorism by somebody who has money, training, expertise, and you can be the suicide bomber. And then you can have your 15 minutes of fame. So that's how everybody now has the capacity of becoming somebody famous, somebody who matters, even without any of the traditional prerequisites. That's why terrorism has become so dangerous, a new level of threat, and will remain a real threat for the time being. There's been a lot of struggle in formulating the response, including the proper legal response to the risk of terrorism. In one academic article I wrote with my collaborator Matthias Vermeulen, we name these evasive strategies by governments as unilateral exceptions from international law, from human rights. Governments have resorted to a whole toolbox of different ways how to avoid their human rights responsibilities in the name of fighting terrorism. Here's just one list of them: wars, state of emergency, reservations, withdrawal, denial of extraterritorial application, and finally, plain disregarding of the law. So some states say, we like human rights, but now we are at war. And during war, inter armas silent leges, laws must be signed. We lawyers say, no, that's not the case. There always was humanitarian law, there was the laws of armed conflict, which had to be respected. Governments say, okay, we respect humanitarian law, but this is a state of emergency. We have the right to derogate, at least from human rights law. That's why we can detain people, and we don't need to give them a trial, and we don't need to give them a lawyer. And we can even treat them a little bit badly, as long as it's only inhuman treatment and not real torture. So that's the notion of derogation. And I already mentioned that one of the reference documents in the fight against terrorism and the human rights dimension of it has been Document 29 by the Human Rights Committee on states of emergency, because of the central place the idea of derogating from human rights plays in the counterterrorism debate. There is the notion of reservations. States can unilaterally declare when they ratify the human rights treaty, yes, we want to be part of the treaty, but not this provision, or we want to modify that provision to the extent that we allow for incommunicado detention of terrorist detainees, for instance. Similarly, there is in many, but not all human rights treaties, the possibility of withdrawal. A state can denounce a human rights treaty previously ratified. One important finding we made with Matthias Vermeulen in that article is that actually states have not resorted to these two. They have not entered reservations to justify their terrorism measures, and they have not withdrawn from human rights treaties. So those are two categories where states haven't taken the opportunities. Some states have derogated formally. Those would be, for instance, Algeria, Russia, Peru, and the United Kingdom. All these countries have entered formal notifications with the Secretary General of the United Nations that they want to derogate from the provisions of the International Covenant on Civil and Political Rights in order to fight against terrorism. Still, it is a handful of countries which have taken the derogation route. More common has been denial of extraterritorial effect. It tends to be the same countries that refer to terrorism as a war, who then also say, yes, we would respect human rights at home, but not when we go abroad, not when we go to war in Iraq, in Afghanistan, or when we otherwise operate extraterritorially, including by detaining terrorists or killing them by drones. We don't have human rights obligations when we act outside our own territory. And terrorists, we don't want to bring to our own territory because we don't want to give them rights. We'd rather take them somewhere else, like Guantanamo. So that has been a big part of the discourse. Do human rights apply to acting governments, even outside their own territory? By and large, the Human Rights Committee has settled the matter in favor of extraterritorial human rights obligations, saying it's not about the physical location of the individual, it's about the degree of exercise of control over the individual, not control over territory, but if you detain, if you torture, if you hire, if you kidnap, if you execute, those are all governmental actions, which means that the person is under your effective control, that is jurisdiction. So that's the Human Rights Committee position. We know that, for instance, the US and partly the UK haven't fully accepted this position. It's been one of the backlashes of the wave of counterterrorism measures since 9/11 that the European Court of Human Rights was susceptible to governmental pressure, primarily in the case of Bankovic and others against Belgium, which was a case decided soon after 9/11, where the European Court of Human Rights accepted in principle that human rights are territorial in nature and would not apply on NATO countries in former Yugoslavia if they were, for instance, bombing the place. If there is ground troops, yes, that is effective control, but bombing is not effective control. Since that Bankovic decision, which was an inadmissibility decision without individual opinions, as in the European Court of Human Rights there are no individual opinions in inadmissibility decisions. Since then, the European Court of Human Rights has been struggling because on the one hand, they want to see the pendulum swinging back. Human rights matter also in the fight against terrorism, and they should have control over what the state does extraterritorially. On the other hand, they haven't wanted explicitly to overrule Bankovic. So nowadays, the European Court, whenever there is question of extraterritorial action, the European Court will say, yes, the Bankovic case is important, but this case is different.
So they decide in favor of extraterritorial human rights obligations, but not explicitly overruling Barkovich, which remains as law in the books. And then, of course, we have the plain disregarding of the law, and it's important to mention this position here because one of the ways the balancing metaphor works is that serious people in serious governmental positions may try to say law or human rights law is just one opinion. That's kind of one expert opinion to listen. It's like I am the minister, I'm in charge of deporting somebody to face torture, a suspected terrorist. I would ask you as the human rights expert, what do you think? And you would say, no, don't send him to torture. And I as minister would say, that's interesting. What do you say as security expert? I would have two opinions, and I would then balance between the two. So that's the plain disregarding of the law, thinking that law is just one opinion, and there are other equally important considerations. When we have resorted in the public discourse to this balancing metaphor, a lot of trouble has emerged. One of them is when we use the balancing metaphor broadly, then we forget the distinction between absolute rights, jus cogens rights, non-derogable rights, and other human rights. Many human rights are subject to restrictions. There is room for some sort of proportionality or balancing. But then there are rights which are not subject to it. And the discussion on torture in the so-called ticking bomb scenario has been a typical case where government officials, even academics, forget that there are absolute rights and not everything can be. Similarly, even where a human right is subject to restrictions, many of us academics say that there's always an inviolable core of any human right. Freedom of expression is subject to limitations, we know that. But still there is an essence of freedom of expression which cannot be balanced, cannot be traded away. So there must be respect for the essential core. And a simplistic balancing metaphor forgets that. I'll get back to the core. It's one of my main points in this lecture. Often in the public discourse, the balancing is done on the abstract level. What's more important? Security of a million people or human rights of one person? And easily you say security of 1 million is more important because you do the balancing on the abstract level. If you do it on the concrete level, you will go through an analytic test of permissible limitations where the last phase is concrete proportionality in the case, not an abstract comparison between values behind the answers. And in that abstract balancing, security always tends to win. So what we saw after 9/11, 2001 was that security was used to justify any indication of human rights utterly social balancing. Even the in relation to that rule of balancing. I mentioned the European Court of Human Rights, which is Bankovic, accepted the territorial nature of human rights without thinking of what the consequences could be. Bankovic was a 9/11 case. The European Court of Human it was heard before. This was a question of a Sri Lankan fundraiser of the Tamil Tigers who was facing deportation from Canada to Sri Lanka, and he, of course, said, "You can't send me to Sri Lanka, I will be tortured if you send me there." What the Canadian Supreme Court decided was that Mr. Suresh was not sent to Sri Lanka, but in its reasoning, the Supreme Court of Canada gave a totally wrong and misleading message that this was a matter of balance. They said, "It is likely that the balance will be struck the same way in most cases, not allowing torture. It would be impossible to say in advance, however, that the balance will necessarily be struck the same way in every case." So what the Canadian Supreme Court is saying, we are not sending Mr. Suresh to face torture, but we might send somebody else to face torture for another day, if we decide to strike the balance in a different way. My point here is that the Supreme Court of Canada did not use the occasion of the Suresh case to emphasize the absolute nature of the prohibition against torture. They did the opposite. Even if they protected the person, they said this is a matter of balance. Canada doesn't like torture. Canada doesn't torture itself. But let's see, let's balance. One day we might send somebody else to face torture. A small detail in the case, I put up front the names of the justices of the Canadian Supreme Court, and you find the name Arbour there. That's Louise Arbour, who later on became the UN High Commissioner for Human Rights. So she was part of the Canadian Supreme Court decision, accepting the balancing metaphor. Not accepting sending an individual person to torture, but accepting reasoning in the framework of balance. That is wrong. That is fundamentally wrong and compromises the absolute nature of certain human rights and compromises the legal bindingness of all human rights by suggesting that everything is ultimately a matter of balance. In one of my reports as Special Rapporteur on Human Rights and Counterterrorism, I formulated the answer like this: law is the balance. Through the careful application of human rights law, it is possible to respond effectively to the challenges involved in counterterrorism while complying with human rights. There is no need in this process for a balance between human rights and security, as the proper balance can and must be found within human rights law itself. Law is the balance, not the way to be measured. You have among the traditional metaphors of law, you have the scale with the two baskets of equal weight. And the task of the equal is exactly to be the balance between the two. Within human rights law treaties, you see the idea in the limitation clauses. You would have, let's say, Articles 8 to 11 of the European Convention saying we have the right to privacy or we have the freedom of expression. It is subject to permissible limitations, towards a legitimate aim, necessary in democratic society, including when it's proportionate towards achieving that aim, and of course when there is a proper legal basis. So legal basis, legitimate aim, necessity, including ultimately proportionality. That's done within the framework of the Human Rights Treaty. There is no other answer. There's no second opinion. The opinion is to be solved within the law, within human rights law, by application of those limitation clauses. Security is a weight in that balancing process, but the answer is achieved within the law. That quote is from my 2009 report as Special Rapporteur on Human Rights and Counterterrorism, and that was a report on privacy. You have the document symbol there, and now the easiest way to find United Nations human rights documents is what? Google. It's not go to the website of the United Nations and write it right. No, no. Just Google with the document, simple. And you will get a couple of answers, but one of them is the correct one. It's right linked to the actual report. So this is 2009 report on the right to privacy in the fight against terrorism. And at that time, not very many people thought it's a highly relevant theme. Traditional NGO people in human rights or traditional litigators in human rights said privacy is too trivial. Go for torture, detention, execution, they are more important issues. And government said it's hopeless. You cannot protect privacy in the fight against terrorism. The right is too amorphous, too vague. The last year we have had a debate on the basis of Snowden revelations, which has proven that privacy has some bite. There are gradually mechanisms, including through courts, through the European Court of Human Rights, through the European Court of Justice, through the US Supreme Court, which mean revitalization of privacy. Privacy is a weak and amorphous right, which is not at its sharpest to protect against counterterrorism measures. But nevertheless, there is an essential core which must remain protected, and there is an analytically rigorous structure. There must be a way to assess whether there was actual proportionality or whether the balancing was made on an abstract level without taking the trouble of proving its necessity, legal basis, and proportionality. So go back to this 2009 report. It, for instance, formulates a structured test for the permissibility of limitations upon privacy. I'll get back to that limitations test first, but let me, in between, address the question of balancing in light of legal theory. Legal theorists, primarily in the analytical tradition, speak for the distinction between rules and principles, and two important names in this discussion are Ronald Dworkin, who passed away 2 years ago, and then the German constitutional law theorist Robert Alexy, active in Kiel. Their notions of rules and principles are quite different. Both of them apply this distinction, and Alexis' approach is much more structured and analytical, and I'm relying primarily upon Alexis. The idea here is that legal norms are either rules or principles. Rules apply in an either-or easy example from the field of human rights. Torture is prohibited. Question is, what is torture? What is the scope of application of the notion of torture? As soon as we are within that sphere, we know the answer. Torture is prohibited. It's a question of defining torture, defining the scope of application of that rule. There is no room for gaps. Why then within human rights law we also have principles which can be realized to a greater or lesser extent. There's a gliding scale, there's variation to the level of enjoyment of human rights. One could say that economic and social rights are typically principles because they can be enjoyed at different levels. For instance, social security benefits can be quantified. And you can say 100 is too little, 1,000 is enough. And then you can have a variation between, but there's a principle that social security must be protected to the maximum level, legally and factually possible, to the maximum of available resources by the country in question. That's part of the economic social rights comment. So some human rights are principles and leave room for balancing, but not balancing without limits. That's the main lesson from the distinction between rules and principles, and then other human rights are excluded from any balancing. My problem with Robert Alexi is that even if he's one of my big heroes in legal theory, in the idea for making clear the distinction between rules and principles, he tends to dilute constitutional rights, in his case, German constitutional rights, to principles only. And he does it by introducing a weight formula and a three-dimensional, three-level scale, small, medium, large. So the weight of the right can be low, medium, high, and the inclusion can be low, medium, high, and you get into a weight formula where everything ultimately is a matter of balance. And then when you ask Alex, what if then there is an absolute equilibrium? You have medium, medium, and medium, medium between two competing rights. Alexi will say, no problem, because you can always fine-tune the scale. Within medium, you can say low medium, 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 high medium. And you can go on in all eternity by fine-tuning the scale so that you find the distinction between the two and one of the rights weighs more than the other. So he starts from the distinction between rules and principles, but then he develops the idea of principles so far that actually rules lose their significance. The Deutsche example, he would say the right in question is very, 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 very high of importance, and the intrusion is very, very, very deep. So there is no competing principle that will weigh as much as that, because you have the maximum numbers on both dimensions, importance and depth of intrusion. Why I think Alex's answer is not adequate is that it's based on his position within the German constitutional rights system. There you can say we have a law-abiding country where all administrative authorities are subject to scrutiny by the courts, and the constitutional court can deal with any new case. They can be confident that we decide today this case, and if there is a new case, we will get a chance to revisit. That's the same weakness that we saw at the Canadian Supreme Court. They also say sending somebody to torture is a matter of balancing, because they trust we will always be those to decide. We don't need to say the balance will always be struck in the same way, because we know we judges, we will always be the ones to decide. So they trust themselves, and they give to the political branches of the government the message: we are not abusing our powers, we are giving you some discretion, but ultimately we want to decide whether the day comes. So that's what people like Alexi and the Canadian Supreme Court say when they reduce fundamental rights to principles. They say, yes, ultimately it's a matter of balancing, but it's for us to balance, and not you. And on the international level, this fails. And I would say the majority of all countries in the world, this fails. Because the executive may not wait for a court decision, may not allow the case to go to the court, may disregard a pending case, may not be subject to international mechanism of complaint, or may not respect the outcome of an international procedural complaint. So I would say that in the international human rights law system, and in a vast majority of all countries in the world, we must insist that there are rules. And that courts, when they once get the chance, will say that there is no room for torture because torture is a rule, and every future case will be decided in the same way and must be decided in the same way. If you're a judge of the German Constitutional Court or the Canadian Supreme Court, you may not want to say that. But if you are a member of the Human Rights Committee, he will want to say to that government and to every other government, it's not for you to balance. It's not even for us to balance, but there must be a clear and absolute rule against torture in every situation. So in Alex's theory, there's a hidden assumption that there will be always a new possibility of weighing the balance in a concrete case, and therefore the court doesn't have the need to declare absolute answers. That does not work in community into other countries. Look at the Suresh decision by the Canadian Supreme Court. It delivers a very bad message to judges in other parts of the world, or to politicians in other parts of the world. They will quote the Suresh decision saying, well, it's a matter of balancing. Not every case needs to be decided the same way. The Canadian Supreme Court has said so. I'll skip the elements of Alex's model of rules and principles. I'll just show you the wonderful mathematical formation. Isn't it great? Look at that. Primarily, Alexei has produced the weight formula for situations where fundamental rights compete with others. We would have those situations such as, let's say, freedom of expression and privacy. Do journalists have the right to publish embarrassing private information about people who are public figures? Does it matter if the person is a politician, a sportsman, or a judge? Can you publish the same degree of embarrassing information to the public? So these are matters for the weight formula to determine. So Alexei will give a value for each of those symbols and will come to an answer which could, for instance, say the politician is free game, has exposed himself to public scrutiny, and almost everything what he does can be put into the press. Whereas judges perform a different function in society. They are also public figures, but they are not there for a career through publicity. They are there for a career through expertise. And it would be harmful for their real job in society if they were free game for the press and anything in their private life, which is not subject of relevance for their judicial function, would be published in newspapers. So Alex's weight formula would say there's a certain threshold for violations of freedom of expression when you punish a journalist for embarrassing a judge, and a different threshold for publishing embarrassing information about the politician. So that's what the weight formula gives. It's geared towards assessing conflicts or tensions between fundamental rights. However, it's done in the framework of constitutional law, and there, of course, you have also so-called collective goods as constitutional principles. And equally well, you can say public security is a constitutionally protected collective good. And there can always be also be a similar process of balancing between public security and individual rights, such as privacy. So some of the elements here you will see are the weight of the principle, weight of the fundamental rights, right? In circumstances, there's the intensity of interference, importance of satisfying the competing principle, reliability of empirical assumptions. I am criticizing Alexei for having the hidden assumption of any future case being subject to becoming decided by the court, the Hercules court. Hercules is a metaphor by working. Basically saying there is always one correct answer to any legal question. One correct answer. Provided we have infinite time by the best possible judge in the world with all of the resources in the world. There will always be one correct answer. And Alexei is a bit the same, that the perfect court will find the perfect balance, as long as every case can be subject to the jurisdiction of the perfect court and it has infinite time to decide the case. There will be no mistakes. But the weakness of Alexei is that the world doesn't function like that, and the international world even less has that head power of giving sufficient attention to every individual case. Okay, on the basis of Alexei, here's a much more simple formula, which expresses the idea that there's plenty of room for balance. These three rights overlap: freedom of expression, privacy, non-discrimination. We may have hate speech, which targets certain minorities, and those three rights become intertwined. And you see there's overlap between all three rights and then pairs of two of each of them. However, every one of those three rights here has an essential core, the darker colored dot. And my idea in drawing this figure is to illustrate that there is no overlap between the cores. And that takes us back to rules and principles. For the interpretation of rules, what was the question? The scope of application. And if we are in the scope of application of a rule, it determines alone that there is no balance. So now we assume that the core of freedom of expression can never overlap with the core of privacy. And therefore, when we define the core, we can safely assume that that fundamental right alone determines the outcome of the case. It would be a privacy right. It would be a freedom of expression violation. But it cannot be at the same time within both of those core areas that would be in competition with each other. Of course, they can overlap in the sense that they are favoring the same person, but there's no tension between the two rights. This is, of course, an assumption. And somebody might say, well, there might be a case where you cannot protect somebody's privacy unless you punish the journalist. And that you end up violating the core of freedom of expression to protect the core of privacy. And I would say, no. You simply need to be more careful in defining the core. Rules become small, rules become complicated in the legal formulation. It's a question of the rule and the exception. Any core area of another right would be a legitimate exception into the core of one right, and hence would reduce the scope of that core. You would still be in the field of defining the scope of application, and you would say, in situations of conflict or tension, only one core of a fundamental right can be applicable, and it alone determines the outcome of the case. So that's the justification for the existence of a core. It comes from the idea of rules and principles, defending that there must be room for rules in order to protect inviolable human rights or the inviolable dimension of any human right. And now I get back to the permissible limitations test. The origins of this list are partly in the limitations clauses of the European Convention on Human Rights, usually framed in three parallel requirements for permissibility of restrictions. There must be legal basis, there must be a legitimate aim, and there must be necessity in a democratic society, including a proportionality test. Usually we have a three-pronged test, but here is a list of 7. That list of 7 conditions can be read from the general comment by the Human Rights Committee on freedom of movement. Freedom of movement, Article 12 of the RCCPR, is one of the provisions where we find a permissible limitations clause as paragraph 3 of Article 12 of the RCCPR. And in 1997, the Human Rights Committee adopted a general comment on freedom of movement, which was the first case in which is really dealt with a right that has a permissible limitations clause, and was explicit in having a section in the general comment of the criteria for what types of restrictions will be permissible. And all these elements can be seen in that document. In my privacy report of 2009, I explained why, even if Article 17 on privacy does not have a full limitation test, but simply refers this to arbitrary and unlawful interferences being prohibited. It should be read in the same way, and this 7-part test would apply also in privacy. So you have this test written into a textual form with references to General Comment 27 in the privacy report. You saw the UN document symbol before. So item 1, provided by the law, that's simple. It's the traditional prescribed by the law in the European Convention. But then already as number 2 comes, inviolability of the court. That has not been articulated in human rights treaties. You don't find it in the European Convention on Human Rights, Articles 8 to 11, but you do find occasional references in the case law by the European Human Rights. Here's a thesis topic. For somebody wanted to write a PhD, essential in the jurisprudence of the human rights. You find a lot of cases, but you wouldn't find any systematic explanation why sometimes the court refers to the existence of an essential court. But you would be able to find these to develop a theory. That theory could then inform the court in the future. But here we have the human rights expression of the process, very violent or also in human rights. In a democratic society, but then the committee says also from the case law of the European Court of Human Rights, from the quality of the law prescribed by that means not only any law, not only existing law, but the proper scrutiny. So each person's discretion left to administrative authorities and the control discretion. There's no unfettered discretion. It's part of the prescribed by law. The tradition of our master legitimate aim, but the Human Rights Committee says it's not enough to be qualified. Let's say by the minister. You can repeat that mantra as many times as you want. It will always be a legitimate aim. But it's not enough. You will also show how you can actually serve that. This is a crucial process. In the contemporary debate, because so much has been done in the name of fighting against terrorism, which has nothing to do with it in terms of delivery. Our security has not been increased, all the measures. Some of them are limited in the EU security, but others are just an obsession by certain authorities to have more and more power without any real effect. It's not enough that there is a legitimate aim, the measure must be necessary for reaching that legitimate aim. And that produces a framework for item 6 that must be proportionality. And the proportionality is not between security and privacy. The proportionality is between benefit to security and the interference in privacy. The proven benefit to workspace security must be proportional in relation to the actual intrusion into fundamental rights. So that's one way to formulate the answer to the main question about balancing. But it's not balancing between security and fundamental rights. It's balancing between actual benefit and the actual limitation to fundamental rights. So we are back in the move from abstract balancing to very concrete proportionality assessment, which is subject to all the other conventions, including the protection of the essence, the core. So proportionality has many dimensions. The measure must be appropriate to deliver security. Among equally effective measures, you must choose the one which is least intrusive, because then you reach better proportionality when you have the same benefit but less intrusion. And it must be proportionate not only towards the interest but towards the delivery of the interest. Finally, consistent with other human rights. Limitations upon one right, for instance privacy, are legitimate only if they do not violate other human rights at the same time. Non-discrimination would be a typical case where you cannot introduce limitations upon privacy that would be discriminatory. Let's say, for instance, ethnic racial profiling would be excluded because it constitutes a violation of other human rights. That's not always an easy case, and there is, for instance, a European Court of Human Rights case called Yellow against the UK, where the court accepts that you can use illegal investigation methods that violate Article 8, right to privacy. And still the trial is essentially fair. So the European Court says first must be compensation for the privacy violation. But the conviction stands because he got a fair trial, even if the evidence was obtained illegally. Here the European Court said you can never violate Article 3 in Ukraine without violation of privacy. But you can violate Article 8 just as compensation for the privacy violation. Problem. The Human Rights Committee is more generous or general, saying any limitations into human rights in order to be permissible must not violate other human rights. So item 2 is the inviolability of the core. I said it is not present in the text of human rights treaties, but it is present where each have fundamental rights. Article 52, paragraph 1. The idea of protected essential core in the jurisprudence of the European Court of Human Rights. We find it in the General Comment by the Human Rights Committee on Freedom of Movement, General Comment 27, paragraph 13, and that's a quote: restrictions must not interfere in essence of the right. You can say core, you can say essence, you can say essential core. They all mean the same, the little dot within the broader framework of human rights. The relation between each fundamental rights is any limitation must, and then there are criteria, respect the essence of those rights and freedoms. So we say essence here. The explanations for the existence of the cooperation are, first of all, the drafting of the EU Charter of Fundamental Rights, which was strongly influenced by the German Commission. And the essential core is part of German constitutional rights doctrine. Secondly, the Charter was first drafted as a declaration, not as a legally binding text, and therefore there were no limitation clauses. That's the background why there then became a general limitation clause, Article 52, which lists the conditions for limiting any of the fundamental rights. And there, the notion of essence was inserted as one of the criteria. So we find support to the position of the Human Rights Committee and to the sporadic references in the case of the European Court of Human Rights that indeed it is one of the conditions for permissible limitations that the measure respects the essential core or essence of the fundamental right. In April of this year, the EU Court, European Union Court of Justice, decided the data retention case. You will remember that as part of the post-9/11 counterterrorism measures, the EU adopted a data retention directive which spells out an obligation to all EU member states to create legislation which requires that telecommunications operators and internet operators store the contact data for a period of between 6 and 24 months. So for every telephone call, every text message, every email, there is a log. What persons or what telephone numbers or IP addresses were in contact with each other, what's the subject line, what's the duration or length of the message, etc. So you have this so-called metadata collection. There is no requirement of storing the substance of telephone calls, recording the calls themselves, or the substance of the emails, but the contact data must be stored for between 6 and 24 months. That measure was challenged from the beginning, and some of the constitutional courts in the United States saw it as a disproportionate measure as implemented in the national legislation, and member states have been struggling how do we implement this directive without breaching upon, for instance, privacy in our constitutional system. Now finally, the European Court of Justice decided the case and said this directive is without legal effect because it breaches two fundamental rights of the EU Charter, right to privacy, Article 7, and right to the protection of personal data, Article 8. So on two counts. They also say has an effect on other fundamental rights, including freedom of expression as well, but it comes through the privacy impact and doesn't need to be addressed separately because the outcome is that the directive anyway is invalid simply because of the intrusion into privacy. Why I mention it here is that that case discusses the question of the essence and refers to Article 52 of the Charter and basically says we are dealing with very important fundamental rights or very important dimensions of fundamental rights. The intrusion is very severe, but it doesn't reach the essence. So they are applying Alexis' weight law. They are giving weight to the fundamental right in context, and they are giving an assessment of the depth of the intrusion. And they are multiplying the two and saying this is too much. It doesn't reach the hardcore, or we don't need to say it reaches the hardcore, because anyway the intrusion is too excessive, to be proportionate, and the directive must fall. So now I have proven that there is a core, an essence. Next PhD thesis topic. The methodology, how to identify the essential core of the human right or human rights in comparative perspective. We know it exists, but how do we find it? And here are just examples to guide your future PhD thesis. The first one is, I think it's a matter of reading interpretation. You can't see it from the text. It's not obvious. You should go through all the case law in order to distill the elements that are truly fundamental and of which, let's say, the European Court of Human Rights has never allowed a deviation. Let's say there are 1,000 cases of freedom of expression, and 500 of them are violations. And in those 500 cases, there have been 10 different parameters, but you would never find a single case when parameter A exists and the outcome is non-violation. So then you would be likely to, through treaty interpretation and the subsequent practice of case law, to establish that this element A looks to be the core, looks to be the essence. Never ever has there been a case where that would not amount to violation. An example, freedom of expression. I would guess that the institution of censorship, advanced censorship by administrative authorities, is an essential core of this. You could never have a system where publishers of books or newspapers would be under an obligation to show to a ministry or prosecutor in advance, we are going to print this tomorrow. Is it okay? The requirement of advanced administrative censorship, I think, would be in violation of the essential core of freedom of expression. What you can have, of course, is subsequent civil and criminal liability. You publish, and you are responsible for what you publish, and then you make a claim to the court. You may be sanctioned by a fine or other penalty. Even your newspaper may be confiscated, the remaining copies, but they are sanctions that operate extra fact. They did not prevent you from publishing, and that's why it's not an essential core question. Okay, this is just an illustration what essential core could be in the question of freedom of expression. I've been working a lot in the field of privacy in recent years and thinking of what's the essential core of privacy. Many people would say it's a vague and amorphous right and there is no essential core in privacy. But I think still you could say there is. I have three candidates here, A, B, C. But then we start no, let's go in this order. So the first candidate is that there are certain categories of sensitive data that would form the essence of privacy. Defining the essence that way is attractive but technically difficult. If you think, for instance, about counterterrorism measures and the need to intercept emails by suspected terrorists, now we presume it's not mass collection. It is targeted collection of emails by persons who are already under suspicion as terrorists. Can you intercept their emails? Balancing? Yes, something is really cooking up. They are planning a terrorist attack. It's imminent. They are communicating between their country of residence and UK and planning an act of terrorism. Maybe you could intercept their email communication. But then comes, is there a sensitive personal information core? That if suddenly something comes up about their sexual orientation or their health in those emails, must it be somehow excluded? Must there be an algorithm that doesn't read those emails when they include health data? That's one candidate for the essential core. Data protection laws, define a category of sensitive personal data. Typically, sexual orientation, religion, health would fall into those categories. That overlaps with item B, confidential relationships. The health data often occurs in your correspondence with your psychiatrist or other medical institution. So you would exclude certain professional or otherwise confidential relationships, and you would institute a firewall into the email interception methods. That if you are a religious institution, if you are a health clinic, if you are a gay club, your emails will never be read, even if the other party is a suspected terrorist. Again, technically difficult, and of course it opens up the question of abuse. The terrorist would establish a gay club as a front for their terrorist activities, because they know it would be correct. But still, as a question of methodology, we can ask whether the question of confidential relationships forms the essence of privacy. There's an old definition of the right to privacy which says the right to be left alone. I don't like this definition. I think it's wrong. But the attractive dimension of the right to be left alone is the idea that there is a forum interne also in privacy. There is a forum interne in freedom of religion. I have the thought, freedom of thought, project of religion, and religion which is not subject to limitations. Nobody can preserve what I think in my mind about God or them. And the same about privacy. Nobody can interfere with what I think myself about my sexual orientation. That's the forum there. The right to be left alone with my privacy. So that would be easy case for the essential core argument. But the more difficult is, can you extend it to your closest relationships, like your spouse or partner or psychiatrist, your lawyer, would those also be part of the core? My definition of privacy is, the right to privacy is primarily a liberty. It's the right of the individual to choose what personal information to share and with whom. So it's a choice. It's my choice. These are the dimensions of my private life I want to share with you, but not you. I can have 1,000 Facebook friends if I want to, and I can share with them personal information if I want to, but still it was my choice to share with them and not with others. And if they breach my confidence, that's a moral fault of them. And a moral responsibility that they didn't respect my privacy. If the government interferes, it's a violation of my legal right to privacy. If they go into Facebook and intercept what my friends will see. So it's a liberty to choose what to share with whom. Primarily, it's a negative obligation by the state to respect my choices, not to interfere. And secondarily, it's a positive obligation by the state to protect my choices against intrusion by third parties. So the government must not itself intercept what I share with my Facebook friends, and it also must have legislation and other infrastructure to prevent abuse by third parties. Third parties being private corporations who would want to fish information out of my Facebook page, or foreign governments, such as the National Security Agency of the United States. My government must protect me against that intrusion. So that's the positive obligation of stepping my privacy as a liberty to choose what to share with whom. You have a question? Who had a question? There was a hand up. I'm sure that. I get the answer. Okay. Third candidate, means of intrusion. In the light of the Snowden revelations, it might actually be easiest to think of the core of privacy so that legislation would simply exclude certain measures as being too intrusive. The idea of sensitive data or sensitive relationships are attractive but also difficult. But what about simply excluding by way of legislation certain measures because they will be intrusive to moral rights? I don't have the answer. I am defending the position that there is an essential form of privacy, and I'm looking for methodology and criteria how to define it. And you can write one PhD thesis, okay? On different rights if you so wish. Any questions at this point?
I understand that in the area of economic, social, and cultural rights, the process depends on resources. Most governments need to allocate resources to different things like military weather and also prioritize the two rights. There has been an effort by some scholars to try and find some basic needs, which seems to be similar to the core the essence of a right. And in the abstract, this is quite a good theory, but in practice, when scholars have tried to actually define these basic needs, because rights are indivisible, it's when they define them, they actually end up saying it's quite a high bar, way above what a lot of governments actually provide, are capable of providing people. I was wondering if you, because a lot of the examples are sort of political rights, whether you think this fundamental essence of the right also applies to second generation rights.
Yeah, the question was whether the same construction covers also economic social rights. I would say yes. There are competing schools as to how we would define the essence of core of economic and social rights. And indeed, one of them is simply quantification. What is the level of the benefit to be paid, the social security benefit? How many dollars or pounds or euros should the level be in society X? So that would be the minimum core content approach expressed in quantitative terms. That's one school of thought. Another one is to think of minimum core obligations of states, which find some support in the language of treaties on economic social rights because they don't speak about individual entitlements, they tend to speak of government obligations to the maximum available resources. So that would be subject much more to availability and reasonableness test. Has the government done everything it can to meet a minimum core obligation? And you would then be prepared to accept situations where people are getting less from than what they actually need, because you cannot ask more from the government. But that's another school. I don't buy my vote. I'm still in the same school of thought that I am in the area of civil and political rights, which is that it's a matter of substantial interpretation. So to me, let's take the right to health. To me, the essential core of the right to health could be, for instance, if the government deprives a person of his liberty or putting him in the prison, then this person is modifying the scope of application. And there is a link to the negative dimension of human rights, that there's a government interference to triggers the obligation to protect at least those people who are in the hands of the government, including prisoners. Again, I don't have the answer, but you can write a thesis on that. Methodology of defining the essential core in the field of economic and social rights or any government. Other questions? You want a break? Let's have a break. I have really a section concerning surveillance and academic work of surveillance. So I can easily leave that after the break. Let's have a 15-minute break.
Yes, we do it up to us, or there's rules, well, we decided to do it first of all, but
Try to yeah, something like well, I think like
So welcome back. So we have two questions during the break, which I want to answer. One question was related to my example of the essential for freedom of expression, the prohibition against advanced administrative censorship before publication. And the question was, does the same apply to electronic publishing, digital publishing, where operators perform some sort of screening or something like. Is it then a violation of freedom of expression, the essential for freedom of expression? Well, yes, no. We put the historical perspective and think of the printing press was invented. It's usually important. The printing press was invented in about 25 years. That's how printed. Technology because with anonymity it's including and transport material across borders, both international travel by insulting people abroad. And advanced censorship was then introduced as one of the mechanisms to keep control over the new dangerous technology of the printing press. It took about 200 years for the appropriate legal solution was found that the and then the publisher bears responsibility. And that was the way how the advanced censorship was abolished. With electronic publication, we are still seeking for that model. We're seeking for a model where the person responsible would always be identified. With the question of current operator being what is the server. That's analogous to the decision by the publisher, the editor. It's certainly by the say that the server, a managing editor of a meeting, is not the same, but simply does attribute responsibility. So performing functions that are similar to the managing editor of a publisher. So it's not advanced censorship. If there was an authority that would check every internet page before it's published, then it would be advanced censorship. But when it is through the issue of attribute responsibility to the owner, the current law, retroactively, then that person is fully consequential analogous to the managing editor of a journal. It never anything, but I would say financial freedom, as long as it's not the government is themselves. It's a favor of the regulator. Better solution will be found. We don't need to make 123 maybe enough in this case. Even that. The other question was about safety. What is the human rights. My first slide, the unilateral of how states are trying to get away from their human rights obligations. And this question about the human rights. It is an important issue of the international community, including the international legal community, in the sense that for national lawmaking, rulemaking is through the international treaties. There is not in the driver's seat. Great states negotiate and draft treaties, and it's only to agreement of all states or a number of states that the new international treaty comes into existence, and then politically consent is the limit to the obligations. So if you have a like-minded states, you want a new treaty, you negotiate the text, and then you adopt it, ratify it, and it becomes binding on you. This is why that the rights law are treaty law, which is on the basis of their voluntary ratification of human rights treaties. There are a number of exceptions where the requirement of consent is eroded. It's not becoming irrelevant, but it's not as absolute as it was before. One example is the two covenants of 1966 do not allow for withdrawal. When they were drafted, no withdrawal clause was inserted. And when North Korea in 1997 tried to denounce the Covenant of Civil and Political Rights, it was told both by states, the legal office of the Secretary General, and the Human Rights Committee that you cannot denounce this particular treaty because there is no withdrawal clause. And if you go back to the Vienna Convention on the Law of Treaties, it supports the idea that not every treaty has to allow for unilateral withdrawal. Some treaties are based on the idea that the parties continue to be bound even if they no longer like the treaty. These treaties are typically in that category. But also human rights treaties if there is no withdrawal clause. So that's a limit to the continued existence of consent. You once consented and you're in. There's no way out. That is then combined with another dimension of human rights law, which is the dynamic and evolutive interpretation of human rights treaties as a living instrument. Under the Vienna Convention on the Law of Treaties, subsequent practice is one of the primary means of interpretation. The drafters may have meant something with the notion of fair trial or inhuman treatment. But the drafters are not those we ask today. Today we ask the European Court of Human Rights what's fair trial and what's inhuman treatment. And states cannot help it, but they simply have to acknowledge that the evolution practice will gradually amount to subsequent practice establishing the agreement of the parties. Occasionally one state may say we don't like the judge, but ultimately they have to give way. So the consent by every individual state at the stage of drafting is not possible for the evolutive interpretation of human rights treaties. One area where consent has its limits has been reservations. Occasionally states, when they enter a human rights treaty, they formulate a reservation saying, okay, fair trial is a great thing, but we can't guarantee a lawyer to everybody. They try to do it in the form of a reservation. They may live with it for 10 years, but then one day the case comes to the European Court of Human Rights or the Human Rights Committee, which says, this reservation, sorry, is contrary to the object and purpose of the trial itself, and hence it will not legal effect. This is called severability. You are bound by the treaty, but you are not benefiting from your own reservation. Here the idea is that the main consent was to be party to the treaty. and it's only a subsidiary dimension, a modification that you set subject to the reservation. Now you're told, you're in, you cannot withdraw, and your reservation doesn't come. Sorry guys, consent was once given, but it is modified through the subsequent practice of treaty interpretation. Here I mentioned the word for human rights. As Professor Brennan it was primarily Novak and myself. We drafted a statute for the Court of Human Rights. Basically, the idea is no new substantive human rights creations, but building on existing human rights legal law and creating the jurisdiction of a world court, which would be compulsory. So it would be elevated human rights to a new level by creating a genuinely judicial body with binding powers, including independent measures, findings of violation, and remedies. All that would be binding judicial powers by the World Court of Human Rights. One dimension in that project is that they explicitly wrote into the statute also about the reservations, that the World Court of Human Rights explicitly will have the competence to review reservations, whether they are compatible with respective humanity and the reservations. So why is the World Court and not an international court? Is that we also bring in the possibility for others than states, international organizations and business corporations become bound by the court simply by unilaterally accepting its jurisdiction. There's still dimension of Utopians or customary international law, where states may be held to account for human rights they never ratified in form of a treaty. Somebody remain outside the treaty framework, might even be the persistent objector to the emergence of a customary law norm, but if the human rights norm is seen as Utopians, even persistent objectors are not immune. They are bound without their consent. This question is partly academic because every state in the world is party to at least one human rights treaty, and all but two states are parties to the full catalog of the Universal Declaration by having ratified at least two human rights treaties. In many cases, the Convention on the Rights of the Child is one of them. All states except Somalia and the US have ratified that treaty, meaning that the full scope of human rights is a treaty obligation by way of voluntary consent in relation to persons under 18 years of age, which often is half the population. So the normative code has been accepted through consent. Why consent still matters there in the question of customary law beyond treaties is that the mechanisms are treaty-based. The obligations, the complaint mechanisms have a treaty basis, and it doesn't always help to say a state is bound by customary law or a state is bound by the Convention on the Rights of the Child if there is no complaint mechanism. But that's a jurisdictional issue. The substantive norms are binding for everybody. So that's the answer to the consent question. Long answer, maybe dimension, but yes, consent has its role, even if limited. Any other questions? Yeah.
So the European Court of Human Rights could be replaced in case of establishment of all the courts.
The World Court would not replace existing regional courts, especially in Europe. The European Court of Human Rights would probably remain the primary recourse of justice for individuals. But you would need to choose. You would need to choose, as you exhaust domestic remedies, which way you go. Whether you go to the regional or whether you go to the World Court. You cannot do parallel to each other or subsequent to each other. We wrote in to the statute the harmonizing interpretation rule, which would be that the World Court would always observe and carefully study and be informed by the jurisprudence of the regional courts. Yes?
And I'm wondering, how would you generate state content to create this rule for it? How realistic is it?
Well, you could ask the same question of the International Criminal Court. People were asking. People were asking, does it make sense to work for decades for the establishment of an International Criminal Court? It's unrealistic. States will never accept it. But then suddenly there was momentum, and now a big majority of all countries, there were the parties to the statute of the International Criminal Court. It's functioning. So the same will happen with the World Court of Human Rights. Intentionally, we wrote the minimum number of ratifications quite low, so that the court could get started with a select group of, let's say, like-minded countries who are willing to take that courageous step. Hopefully we will get some international organizations on board and some business corporations, and then it would be a fantastic, successful experience, and everybody would rush to become part of this. I said it's only jurisdiction. The existing human rights treaties would remain in place, no new legal applications. The existing monitoring mechanisms will exist in place unless accepts the jurisdiction for it. It would then yes. Yeah.
Yes, my question primarily on the balancing of rights. I saw that some of your examples dealt with individuals, rights to individuals. Not really looking at property rights, there's also the right of corporations or legal persons. You have a situation whereby if you have a situation whereby the conflicting rights of individuals and corporations are against one another, how do you see a courts balancing those rights, or is that possible? For instance, I know in the EU Convention there's the right of enjoyment of one's possession as well as the African and American legal systems.
Well, courts in general are very well placed in balancing the interest of competing parties. That's the job of the court, to be the neutral party between the two original parties, and it really doesn't matter or shouldn't matter if it's a power imbalance between an individual and a corporation. The court should be impartial and independent and be in an institutional position where it can do the fact-finding and hear the legal argument and make a just decision to resolve that tension. That said, that's a reference to ordinary national courts. I think human rights courts or human rights bodies are different. And here speaks the conservative in front of you, that human rights were created to deal with the relation between the individual and the state. And still today, human rights mechanisms are about the individual confronting his or her state, or the state that has exercised the jurisdiction. And third parties are not genuinely involved. So I'm actually quite cautious about human rights courts trying to do too much of balance. One of my PhD students now is writing about the rights of the child in relation to the parents in the field of religion, education, corporal punishment, etc. And she's trying to say that the European Court of Human Rights is doing and should be doing balancing between the rights of the different affected individuals. And I question that approach by saying, why should it be? Isn't it enough that there is one individual coming to the European Court of Human Rights? And the question is whether the state violated the human rights of that individual. I can very well imagine that there will be 3 cases before the European Court by the child, by the parent, by the mother, all complaining that the state has violated their human rights in a child dispute case, a bitter child dispute case.
Your case pending like this right now.
Okay, and the court could very well say, yes, every one of them was victim of a violation of human rights. There would not be a genuine need to balance between the interests of the individuals when you restrict yourself to finding whose human rights were violated and whose human rights were not. Similarly with freedom of expression and privacy, you could imagine a situation where both the first person whose private life was disclosed to public scrutiny and the journalist were victims of human rights violation. For instance, if the state didn't provide a fair trial, both people were victims of a violation, even if they originally were adversarial parties on the domestic level. So I don't think human rights can fix everything or should fix everything. Human rights law is not about how every individual should live his or her life. Hopefully we have some liberty, and nobody's going to tell us every choice of our own private life. We can do those choices ourselves, and as long as we don't commit crimes, we go free. Even if we are bad people. More than bad. As many of us are. Other questions?
What to do with power?
Sorry?
What to do with powerful countries imposing human rights for their interests?
I didn't get the first word.
What to do with powerful countries impose human rights for their interests? There is a consequence because these other countries, they are not going to believe, they are going to trust in human rights.
Well, again, it's a question of the human rights bodies limiting themselves to their own reality. Trying to fix everything in the world, something is left for politics, something is left for other types of judicial bodies. The human rights bodies should look at the rights of the individuals and whether this or that state violated them. And it may be that the weak state did not violate human rights when it acted under the pressure of a powerful state, or it may be that it still is held accountable. Now we are suddenly out of time. I have to say something about surveillance. No more questions. Thanks. This is where I wanted to be. No. Okay, I'm currently involved in a EU FP7 project called Surveillance, ethical issues, legal limitations, and efficiency. And I'm going to show those slides in this view because my computer is crashing. Just from these slides, right? Computer doesn't like. Yeah, that's the name of the project. Surveillance, ethical issues, legal limitations, and efficiency. What we are doing is that we are trying to assess surveillance technologies on those three dimensions. What are the ethics of surveillance? That's done by our philosopher team. What are the legal limitations, primarily stemming from human and fundamental rights? And what's efficiency in surveillance? And the efficiency here refers to the proven security benefit of utilizing surveillance. This is a multidisciplinary project, so that we have engineers, technical scientists, and technology assessment people including from the field of sociology, so there will be the societal effect as well. Doing the technology assessment. What surveillance technologies produce good results? Catching criminals, preventing terrorism, maintaining public order and security. Which surveillance methods actually deliver? Results in usability score. That's the left-hand column. If you see the numbers, they are 6, 7, 9, 8, 8, 3, 4, 5. That first exercise was based on a traditional organized crime scenario. There was some drugs involved, some weapons involved, some risk of violent crime, murders being committed by an organized criminal group, and a sequence of various surveillance technologies were applied. And as you see, there's quite variation in the usability scores. Some work, some don't. Number 6 is a sound recording bug on public transport used by the target suspect. Only 3. Whereas number 3 score is 9. Covered photography in public space. Good identification, done secretly, etc. delivers what it's meant for. So the usability score is between 0 and 10. One way to measure, in terms of Alexi, the security benefit, the actual delivery, and it would enable the proportionality assessment. You don't compare apples and oranges, or if you do, you need to know how many oranges, and here you have a lot of oranges produced by the surveillance. The colors are the ethics code. White means no ethical issue identified. Green means minor ethical issues, go ahead, drive ahead. Yellow, warning, be cautious, and red, stop, don't do it. So we also have quite nicely different colors of ethical risk triggered by the use of these surveillance technologies. And then the 2 columns of numbers in the middle are the legal assessment of data protection on the left and privacy on the right. And as you see, the scores range from 3/4 to 16. The fundamental rights intrusion was an adaptation of Alexis' model. Importance of the fundamental right in the context, 1, 2, or 4, low, medium, high. Depth of intrusion, 1, 2, or 4, low, medium, high. And the maximum score is 4/4, 16. Minimum would be 0/0 is 0. In practice, 1/1 is 1. And then we had the reliability of empirical assumptions. In our case, reliability of our legal assessment primarily based on the existence of analogous European Court of Human Rights case law. If there is no case law, we use the 3/4. So 3/4 is 1/1/3/4 as a result. 16 is 4/4, and certainty of case law is 1. Huge variation. And you see that some technologies give good usability scores and low fundamental rights intrusion, and at best only yellow ethical risk, medium level ethical risk. And one could say that here our scoring says use these technologies. Of course there needs to be a legal basis, of course there needs to be oversight, but it looks like the security benefit is greater than the fundamental rights intrusion. Then some others, like the sound recording bug in the target's home address, it gives a high usability score, 8, 10 is the maximum. But what's problematic is red light for the privacy intrusion, maximum scores of 16, both for data protection and privacy, and an asterisk, which means significant third-party intrusion. So don't install sound recording bugs at people's home, was the conclusion here. We did a second exercise, which is emulating the Snowden revelations. We drafted a narrative how terrorism prevention is done by the use of the NSA GCHQ mass surveillance methods. Of course, already this has assessment is biased in the sense that we were assuming that there is a real terrorist attack being planned. And that's why they resort to mass surveillance. But it starts with the splitting of the fiber optic cable in the English Channel. Then there is a filtering tool, a phantom viewer, to use algorithms to detect cases for further interest. Then there is a social networking analysis for the targets identified through the filter, a limited group of users. And then we get to traditional surveillance. We have identified a target, a suspected terrorist in London. The surveillance team was sent to do visual observation, and internet cafes that he was visiting were subject to the installation of a surveillance tool called FinSpy, which is a micro-level internet monitoring device which allows for real-time observation of Skype, email, etc. when the person is at the computer. So in between there was an opening of a suitcase. What we found was that the mass surveillance methods produce at best low-level, medium-level usability scores. Because they are so massive and non-selective, they don't work very well. So we get the scores 5 for the 2 first ones and 4 for the last one, whereas the traditional methods work better. The visual observation of a suspect, opening a suitcase, or even the electronic social networking analysis when you already have a suspect, when you are being able to target, then it works and gets a usability score of 8. So mass surveillance doesn't work very well. Plus, you see the fundamental intrusion is at maximum at the mass surveillance tools, 16. So there is no proper balance between the benefits for security and the depth of the fundamental rights intrusion. So our analysis suggests that the mass surveillance fails on both technological usability and the intrusion. It also gives red lights by the ethicists. And what we actually can recommend is the items 4 and 5, which are the traditional non-technological surveillance methods in countering terrorism. Opening a suitcase to detect whether there is explosives or ingredients of explosives when somebody crosses an international border, and sending a surveillance team physically, visually, to observe what the person is doing. They give good usability scores, low fundamental rights intrusion, 3 quarters, and low or medium level ethical risk. The only compromise, only area of actual balancing is the social networking analysis. When we have the names of the suspected terrorists, can they be subject to social networking analysis, including through utilizing what's available of them in the electronic domain? We get quite high usability scores, we get a high fundamental rights inclusion score, but it just happens that they both are at 8. So one could say this is genuinely a situation of balance. The ethical risk is at yellow, also suggesting that one has to be very cautious. The bottom line here would be you cannot categorically exclude those measures when you have a suspect and you limit yourself to social networking analysis which doesn't extend to the sensitive content of the communication, but simply creates a social networking graph. So we say that's where the balance roughly is. Mass surveillance fails, traditional foot soldiers, surveillance teams, fine, and limited targeted surveillance is at the border. That's it. Questions? Yes, please.
But isn't mass surveillance necessary to identify the suspect? Isn't surveillance necessary to identify suspects and then respond to them with traditional means?
Our analysis suggests that no, because it isn't effective in producing the names of the actual suspects. That it's much more likely that the names of the suspects would be found through other measures. And I think everything we know about them supports this conclusion. We don't know of a single case where the electronic mass surveillance methods would have produced real suspects of terrorism. But we know of many cases where the US authorities failed to follow the leads they had because they were so obsessed with the collect evidence. So it's like the needle in the haystack metaphor, that the logic of the NSA has been, there are many needles in the world, they must be somewhere in a haystack. So let's collect first all the hay in the world and find the needles. I would go to the needle factory to look for needles, not in the haystacks. They are much more likely to be found there. Okay, now everybody wants to speak at the other time. You are first. Microphone.
Both the FilSpy software and other software suites like this are usually marketed through normal means by companies registered in several countries. Is it your personal view that the countries where this software developers are based should basically ban the activities of such companies that are producing and marketing the software, such as FilSpy, that can potentially allow governments or private entities to have an umbrella spying mechanism on everything?
Should, yes, like EU countries should regulate the production and export of torture equipment, they should also be careful in exporting surveillance technology to oppressive regimes. And ultimately, this will be a matter of complicity in a crime or complicity in a human rights violation if you haven't paid attention from the beginning. I don't think there's an issue of a core or a red line where to draw it. But I think it's good that the EU is discussing principles, rules concerning export of surveillance technologies and software.
Actually, production. It's not at all the means that, okay, the final means for many companies is to export this to oppressive regimes. But sometimes without this means, the company is making something that can potentially be used for human rights violation on unbelievable scale.
I think it's useful to ask the question, what technology should not be developed, what technology should not be allowed to develop, what technology should not get public funds to be developed. Much of the EU technology research is not about social science criticizing technologies, but it's actually giving a boost to European industries in developing intrusive technologies. And there, certainly, it's easy to say that the EU should not be funding the development and the deployment of intrusive technologies, but the issues of privacy and other fundamental rights should be a leading consideration already at the early phase of technology development when the funding is being sought. So move it earlier is my answer. Any other questions? There at the back in the middle.
Yeah, well, thank you. I think maybe in some ways just answered the question, but for instance, if we look at the phantom viewer technology, I'm assuming that these scores and the fundamental rights intrusion rating are based on sort of empirical knowledge of a particular technology. So for instance, wouldn't you say that if in theory in the future somebody were developing a phantom viewer technology, that number one had an algorithm that was much more focused, so the usability score would be raised, and number two, as you were just stating, in the early stages took into consideration privacy concerns For instance, let's say a perfect black box were created where there were no human hands, no human access, and that were in theory guaranteed. And the only thing that kicked out of this algorithm that ran were the so-called bad actors. Would that, in your view, under this matrix system, reduce the fundamental rights and intrusion score, and therefore, result in possibly a different kind of rating?
Definitely yes. The usability score is 0 to 10, and there are 3 points out of 10 are related to privacy by design. So we kind of give a double reward for privacy protective features because it would introduce privacy by design features, increases the usability score, and lowers the intrusion score. So there is a double benefit whenever you introduce those features. They are inbuilt in the system. One more question, then lunch. You at the front.
Thank you. So thank you for the presentation. My question is more pragmatic. And in terms of the empirical part of the project, what happens, for example, I live in Canada, and what in terms of the technologies from the US and Canada, most of them, in terms of choice of prevention, they're highly classified, and you will never know. So these are the technologies that we know. But what about all the ones that we don't know? In terms of the index, I think it can affect the ethical risks and usability.
Well, I think the last year shows in practice that even if technologies and their use is classified, secrets tend to remain secrets only for a limited time. And I think what we are seeing in the US now is really the pendulum swinging back, that all the layers of secrecy built into the use of surveillance, secret courts administering vague laws, classification of all documents and all technology, I think it's going to result in a backlash because it undermines the legitimacy of the surveillance itself. And the US Supreme Court and other federal courts are now stepping up to protect privacy and other fundamental rights, partly because of the secrecy that surrounds it. So it is a backlash which now works very unfavorably in relation to surveillance. So better transparency, more precise legislation, more publicity to oversight mechanisms would be a guarantee to protect those dimensions of surveillance that are worth keeping. I think we must move that way. There must be public laws about the criteria, who can be subject to surveillance, and about the intrusion, what fundamental rights are affected, even if you cannot expect that the technical details will be spelled out in legislation. But you must be allowed to authorize the intrusion in precise terms that can be subject to oversight. All right, thank you very much. I hope you will have an excellent summer school with Bill Chambers and other fine colleagues of mine. Good luck.